Q. Consider the following.
1. An elected head of the state.
2. A bicameral legislature.
3. Ministers accountable to the parliament.
4. An independent judiciary.
How many of the above are necessary feature S of the Westminster system of government?
A. Only 1. B. Only 2. C. Only 3. D. All 4. Answer B. Explanation.
The parliamentary form of government is also known as the cabinet form of government or responsible government or Westminster model of government. It is prevalent in Britain, Japan, Canada and India.
Among others,
Westminster is a place in London where the British Parliament is located. It is often used as a symbol of the British Parliament. The Westminster system comprises a head of state, the sovereign or their representative. India has a republican system in place of the British monarchical system. In other words, the head of the state in India, that is, the president, is elected, while the head of the state in Britain, that is, king or queen, enjoys a hereditary position. So, point 1 is not correct. An elected parliament made up of 1 or 2 houses. Some countries like Canada and Australia have bicameral legislatures, while countries like New Zealand and Israel have unicameral legislatures. Thus, a bicameral legislature is not a necessary feature of the Westminster model.
So, point 2 is not correct.
A government formed by the political party or coalition that has majority support in the lower
House of Parliament.
A prime minister or premier, who heads the government. A ministry, drawn from members of parliament, usual members of the government, who exercise executive authority and are accountable to the parliament. So, point 3 is correct. An independent judiciary. So, point 4 is correct. So, only 2 of the above are necessary features of the Westminster system of government. Therefore, option B is the correct answer.
Brought to you by audio.ai.
Consider the following statements with reference to the office of prophet. 1. The expression, office of prophet, has neither been defined in the Constitution, nor in the Representation of the People
Act 1951.
2. The final decision on disqualification of a member of Parliament for holding an office of prophet rests with the Parliament. Which of the statements given above are
correct? A. 1 only. B. 2 only. C. Both 1 and 2. D. Neither 1 nor 2. Answer A. Explanation.
The expression, office of prophet, has neither been defined in the Constitution nor in the Representation of the People Act, 1951, or in the Parliament, Prevention of Disqualification, Act, 1959. Evidently, because it is not easy to frame an all-embracing definition, covering all the different kinds of posts which exist under government and those which might hereafter be created. So, Statement 1 is
correct.
Unless otherwise declared by Parliament by law, a person is disqualified for being chosen as, and for being, a member of either House of Parliament if he holds any office of prophet under the government of India or the government of any state. If any question arises as to whether a member of Parliament has become subject to any of the disqualifications laid down in the Constitution, including the one whether he is holding an office of prophet or not, the question is referred for the decision of the President and his decision is final. However, before giving any decision on any such question, the President is required to obtain the opinion of the Election Commission and shall act according to such opinions. It is important to note that in this matter the President does not act on the advice of his Council of Ministers. In Ashok Kumar Bhattacharya vs. Ajoy Biswas, the Supreme Court held that to determine whether a person holds an office under the government, each case must be measured and judged in the light of the relevant provisions and sections. The final interpretation and decision of whether a person is disqualified or not rests with the courts and not with the Parliament. So, Statement 2 is not correct. Therefore, option A is the correct answer. Consider the following statements with reference to the Constituent Assembly of
India.
1. It was constituted as per the scheme formulated by the Cabinet Mission Plan. 2. It served as India's provisional parliament until the formation of the new parliament following the first general
Elections.
3. H.C. Mukherjee and V.T. Krishnamachari were vice presidents of the Constituent
Assembly.
How many of the above statements are
Correct? A. Only 1. B. Only 2. C. All 3. D. None.
AI.
Answer C. Explanation.
The Constituent Assembly was constituted in November 1946 under the scheme formulated by the Cabinet Mission Plan. The arrangement was, 292 members were elected through the provincial legislative assemblies, 93 members represented the Indian princely states, and 4 members represented the chief commissioners' provinces. The total membership of the assembly thus was to be 389. However, as a result of the partition under the Mountbatten Plan of 3 June 1947, a separate Constituent Assembly was set up for Pakistan and representatives of some provinces ceased to be members of the Assembly. As a result, the membership of the Assembly was reduced to 299. So,
Statement 1 is correct.
in all, the Constituent Assembly had 11 sessions over 2 years, 11 months and 18 days. The concluding session of the Constituent Assembly took place on January 24, 1950. Rather than coming to a complete close, it seamlessly transitioned into the Provisional Parliament of India on January 26, 1950. This transitional role persisted until the establishment of the new parliament following the inaugural general elections in 1951-52. So, Statement 2 is correct. The Constituent Assembly held its first meeting on December 9, 1946. The Muslim League boycotted the meeting and insisted on a separate state of Pakistan. Dr. Sachidananda Sinha, the oldest member, was elected as the temporary president of the Assembly, following the French practice. Later, Dr. Rajendra Prasad was elected as the president of the Assembly. Similarly, the Assembly had 2 vice presidents, H.C. Mukherjee and V.T. Krishnamachari. So, Statement 3 is correct. So, all 3 of the above statements are correct. Therefore, option C is the correct answer.
AI.
Consider the following statements. The preamble to the Constitution of India.
Secures for all its citizens.
1. Political, social and economic justice. 2. Unity and integrity of the nation.
3. Federal form of government. 4. Liberty of faith. 5. Dignity of the individual.
Which of the statements given above are
Correct? A. 1, 2 and 3 only. B. 1, 2, 4 and 5 only. C. 2, 3, 4 and 5 only. D. 1, 3 and 5 only.
AI.
Answer B. Explanation.
The preamble to the Indian Constitution is based on the Objectives Resolution, drafted and moved by Jawaharlal Nehru in the Constituent Assembly. It has been amended only once by the 42nd Constitutional Amendment Act, 1976, which added 3 new words: socialist, secular and integrity. The objectives stated by the preamble are to secure justice, social, economic and political, liberty of thought, expression, belief, faith, and worship, and equality of status and opportunity to all citizens, and to promote fraternity, assuring the dignity of the individual and the unity and integrity of the nation. So, points 1, 2, 4 and 5 are correct. The term federal has not been mentioned anywhere in the preamble and the Constitution of India. So, point 3 is not correct. Therefore, option B is the correct answer. We, the people of India, having solemnly resolved to constitute India into a sovereign socialist secular democratic republic and to secure to all its citizens justice, social, economic and political, liberty of thought, expression, belief, faith and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly this 26th day of November, 1949, do hereby adopt, enact and give to ourselves this Constitution.
AI.
The Nari Shakti Vandan Adhinayam, 2023.
That provides for 33% women reservation of seats in the Lok Sabha and state legislative assemblies, is based on the principle of
A. Equality of opportunity. B. Equality before law. C. Affirmative action. D. Equal rights.
AI.
Answer C. Explanation.
the Nari Shakti Vandan Adhinayam, 2023, 106th Constitutional Amendment Act, has been passed by the Parliament recently. It provides for 33% reservation of seats for women in the Lok Sabha and state legislative assemblies. It includes provisions for horizontal reservation that cut across different quota categories. Particularly, women from the scheduled caste, SCs, and scheduled tribes, STs, are proposed to have 1/3 of the seats allocated for SCs and STs in the Lok Sabha and legislative assemblies. These efforts are aimed at increasing women's participation in the legislative process, even among groups that have historically been
Underrepresented.
The principle of affirmative action provides for special assistance to enable the backward communities to overcome the existing disadvantages and then compete with others on equal terms. The policies of affirmative action are supported for making the society more equal. For example, banks offer higher rate of interest to senior citizen in order to promote inclusive growth. The Nari Shakti Vandan Adhinayam, 2023, Women's Reservation Act, is a similar effort to provide for special assistance to enable women to overcome the existing disparities in their representation in the Lok Sabha and the legislative
assemblies.
The principle of equality of opportunity aims to prohibit discrimination of certain grounds and create a level playing ground to be able to compete on equal terms. For example, the provision of free education to every child without any class-based bias is based on the principle of equality of
opportunity.
The principle of equal rights encompasses the right to be treated equally irrespective of any discrimination based on age, sex, race, etc. For example, the provision of the right to vote to all citizens is based on the principle of equal rights. The concept of equality before law is of British origin. The first concept connotes a. the absence of any special privileges in favor of any person, b. the equal subjection of all persons to the ordinary law of the land administered by ordinary law courts, and c. no person, whether rich or poor, high or low, official or non-official, is above the law. This principle thus prohibits special privileges in favor of
any person.
Therefore, option C is the correct answer. Relevance. Recently, the Women's Reservation Bill has been passed by the Parliament as the 128th Constitution Amendment Bill, which later became the 106th Constitutional Amendment Act, 2023. The Government of India Act of 1919 provided for which of the following?
1. Bicameralism at the center.
2. Half the members of the Viceroy's Executive Council were to be Indians. 3. Appointment of a statutory commission. 4. Offices of the President and Deputy
President in Central Legislature.
5. Establishment of a Council of India. Select the correct answer using the code
given below. A. 1, 2, 3 and 4 only. B. 2, 3 and 5 only. C. 1, 4 and 5 only. D. 1, 2, 3, 4 and 5. Answer A. Explanation.
The Government of India Act, 1919, was founded upon the widely recognized Montagu-Chelmsford reforms. In the August 1917 proclamation, the British government expressed its aim of progressively instituting accountable governance in India, while maintaining an essential link with the British Empire. The features of this act were as follows. It introduced, for the first time, bicameralism and direct elections in the country. Thus, the Indian Legislative Council was replaced by a bicameral legislature consisting of an upper house, Council of State, and a lower house, Legislative Assembly. The majority of members of both houses were chosen by direct election. So, point 1 is correct. It required that 3 of the 6 members of the Viceroy's Executive Council, other than the Commander-in-Chief, were to be Indian. So, point 2 is correct. It provided for the appointment of a statutory commission to inquire into and report on its working after 10 years of its coming into force. So, point 3 is correct. The institutions of Speaker and Deputy Speaker originated in India in 1921 under the provisions of the Government of India Act of 1919, Montagu-Chelmsford reforms. At that time, the Speaker and the Deputy Speaker were called the President and Deputy President respectively, and the same nomenclature continued till 1947. Before 1921, the Governor-General of India used to preside over the meetings of the Central Legislative Council. So, point 4 is correct. Council of India was established by the Government of India Act of 1858 and was abolished by the Government of India Act of 1935. The Secretary of State for India was provided with a team of advisors.
So, point 5 is not correct.
Therefore, option A is the correct answer.
AI.
Consider the following statements with
reference to the Parliament.
1. As per the Constitution of India, both the Lok Sabha and the Rajya Sabha are to be summoned and prorogued on the
same dates.
2. Adjournment terminates a sitting as well as the session of the House of
Parliament.
3. The prorogation of the House brings to an end all bills or any other business
pending before it.
How many of the above statements are
correct? A. Only 1. B. Only 2. C. All 3. D. None. Answer D. Explanation.
The President of India from time to time summons each House of Parliament to meet. The maximum gap between 2 sessions of Parliament cannot be more than 6 months. A session of Lok Sabha comprises the period commencing from the date and time mentioned in the order of the President summoning Lok Sabha and ending with the day on which the President prorogues or dissolves Lok Sabha. It is not necessary that Lok Sabha and Rajya Sabha should be summoned and prorogued simultaneously or on the same dates. Until 1961, sessions of the 2 houses generally commenced on different dates except for the first session of every year when the President addresses members of both houses assembled together. However, since 1962, generally both the houses have been meeting simultaneously, so, statement 1 is not correct. Adjournment of the House only terminates a sitting and not a session of the House. Prorogation of the House not only terminates a sitting but also a session of the House. So, statement 2 is not correct. Upon the conclusion of the session's proceedings, the presiding officer, Speaker or Chairman, proclaims the House adjourned sine die. Following this, within a brief span of time, the President releases an official notification for the session's prorogation. It is important to note that the President retains the authority to prorogue the House even while it is actively in session. Prorogation of the House does not affect the bills or any other business pending before the House. However, all pending notices, other than those for introducing bills, lapse on prorogation and fresh notices have to be given for the next session. In Britain, the prorogation of the House brings to an end all bills or any other business pending before the House. So, statement 3 is not correct. So, none of the above statements are correct. Therefore, option D is the correct answer. Which one of the following statements best describes the sovereign nature of the Indian
state?
A. India cannot acquire a foreign territory or cede its territory in favor of a foreign
state.
B. India has an elected head of state. C. India vests its political sovereignty in the
Parliament. D. None of the above. Answer D. Explanation.
According to the preamble, India is a sovereign state. Such a proclamation was made to denote the end of British rule over India. It testifies to the fact that India is no longer a dependency or colony or possession of the British Crown. Though in 1949, India declared the continuation of her full membership of the Commonwealth of Nations and accepted the British Crown as the nominal head of the Commonwealth, this extra-constitutional declaration does not affect India's sovereignty in any manner. Being a sovereign state, India can either acquire a foreign territory or cede a part of its territory in favor of a foreign state. Therefore, option D is the correct answer. Consider the following statements. Statement I. Article 1 of the Constitution describes India as a union of states rather than a federation of states. Statement 2. The Union of India is not the result of an agreement among the states. Which one of the following is correct in respect of the above statements? A. Both Statement I and Statement 2 are correct and Statement 2 is the correct
explanation for Statement I.
B. Both Statement I and Statement 2 are correct and Statement 2 is not the correct explanation for Statement I. C. Statement I is correct but Statement 2 is
incorrect.
D. Statement I is incorrect but Statement 2
is correct.
AI.
Answer A. Explanation.
The Constitution of India envisages a federal government where there is a division of powers between the center and regional governments. Article 1 of the Constitution of India states that India, that is, Bharat, is a union of states. So, Statement 1 is correct. According to Dr. B.R. Ambedkar, the phrase Union of States has been preferred to Federation of States for two reasons. 1. The Indian Federation is not the result of an agreement among the states like the American Federation, and 2. The states have no right to secede from the Federation. The Federation is a union because it is indestructible. So, Statement 2 is correct. So, both Statement I and Statement 2 are correct and Statement 2 is the correct explanation for Statement
I.
Therefore, option A is the correct answer. Which of the following statements are considered to be unitary features of Indian
federalism?
1. The residuary powers are given to the center under the Constitution of India. 2. The power of the states to raise their own revenue resources is limited. 3. States' executive power is coextensive with their legislative powers. Select the correct answer using the code
given below. A. 1 and 2 only. B. 2 and 3 only. C. 1 and 3 only. D. 1, 2 and 3. Answer A. Explanation.
Quasi-federal refers to a system of government where the distribution of powers between the center and the
state are not equal.
The Constitution of India establishes a federal system of government. However, the Indian Constitution also contains a large number of unitary or non-federal features, viz., a strong center, single constitution, single citizenship, flexibility of constitution, integrated judiciary, appointment of state governor by the center, all India services, emergency provisions and so on. Hence, the Indian Constitution has been variously described as federal in form but unitary in spirit. India is often described as quasi-federal in nature because of the following reasons. Part 11 of the Constitution, Articles 245 to 263, deals with center-state relations. It covers legislative and administrative relations between the parliament and states. The peculiar phrase, unitary bias, arises because residuary powers, the power to legislate on matters not enumerated in the central, state, or concurrent list of subjects, are given to the centre under Article 248 of the Constitution of India. This is unlike the constitutions in many other federations such as the United States, Germany and Australia where such power is conferred on the states. So, Statement 1 is correct. In fiscal matters, the power of the states to raise their own resources is limited and there is a good deal of dependency on the centre for financial assistance. So, Statement 2 is correct. The states are sovereign in their prescribed legislative field and their executive power is coextensive with their legislative powers. However, this is not a reason for India being referred to as a quasi-federal. India has a unitary bias because the powers of the states are not coordinate with the Union. So, Statement 3 is not correct. Therefore, option A is the correct answer.
AI.
Which of the following states were not created by the States Reorganization Act of
1956? 1. केरला 2. हिमाचल प्रदेश 3. हरियाणा 4. आंध्र प्रदेश 5. गुजरात
Select the correct answer using the code
given below. A. 1, 2, 3 and 4 only. B. 2, 3 and 5 only. C. 1, 4 and 5 only. D. 1, 2, 3, 4 and 5. Answer B. Explanation.
The States Reorganization Act, 1956, was enacted by the Parliament under Article 4 of the Constitution of India to give effect to the scheme of reorganization which emerged from the consideration of the proposals contained in the States Reorganization Commission, SRC, report. The new states formed as a result of the reorganization of states in 1956 are Andhra Pradesh, Bombay,
Kerala, Madhya Pradesh, Madras, Mysore, Punjab and Rajasthan.
The Act established the new state of Kerala by merging the Travancore, Cochin state with the Malabar district of Madras state and Kasaragod of South Kannada, Dakshina Kannada. The Act merged the Telugu-speaking areas of Hyderabad state with the Andhra state to create
the Andhra Pradesh state.
Further, it merged the Madhya Bharat state, Vindhya Pradesh state and Bhopal state into the
Madhya Pradesh state.
Similarly, it merged the Saurashtra state and Kutch state into the Bombay state, the Coorg state, into the Mysore state, the Patiala and East Punjab States Union, PEPSU, into the Punjab state, and the Ajmer state into the Rajasthan state. In 1960 by the Bombay Reorganization Act, 1960, the bilingual state of Bombay was divided into two separate states, Maharashtra for Marathi-speaking people and Gujarat for Gujarati-speaking people. Gujarat was established as the 15th state of the Indian Union. In 1966, the state of Punjab was bifurcated to create Haryana, the 17th state of the Indian Union, and the Union Territory of Chandigarh. On the recommendation of the Shah Commission, 1966, the Punjabi-speaking areas were constituted into the unilingual state of Punjab, the Hindi-speaking areas were constituted into the state of Haryana, and the hill areas were merged with the adjoining Union Territory of Himachal Pradesh. In 1971, the Union Territory of Himachal Pradesh was elevated to the status of a state, 18th state of the Indian
Union.
Therefore, option B is the answer. Relevance. The 66th anniversary of the passage of the States Reorganization Act, 1956 by the Indian Parliament
was recently celebrated.
Which one of the following statements best describes the principle of checks and
balances?
A. Each organ of the government works in a way to prevent the other from becoming
authoritarian.
B. A legislature needs the approval of all states for any constitutional amendment. C. Laws made by the state legislature are not applicable outside its territorial
jurisdiction.
D. A legislature that does not possess the power to make law upon a particular subject directly cannot make it indirectly.
Also.
AI.
Answer A. Explanation.
The principle of checks and balances states that each organ of the government shall act on the other organs in such a way as to prevent them from becoming totalitarian and to prompt them toward fulfilling their constitutional obligations. Various provisions under the Indian Constitution provide for checks and balances in the governance framework of India so as to reduce errors, prevent improper functioning and decrease the risk of
centralization of power.
For example, Article 61 provides for the impeachment of the President by the Parliament. Article 103 gives power to the President to finally decide on the disqualification of the members of Parliament, MPs, based on the opinion of the Election Commission. Therefore, option A is the correct answer. Consider the following statements with reference to a no-confidence motion in the
Parliament.
1. A motion of no confidence must set out the grounds on which it is based. 2. Not more than one no-confidence motion can be moved in a parliamentary session. 3. Till now, no central government has ever had to resign following a vote of no confidence taken in the Lok Sabha. Which of the statements given above is R?
Correct? A. 1 only. B. 3 only. C. 2 and 3 only. D. 1, 2 and 3. Answer B. Explanation.
Article 75 of the Constitution says that the Council of Ministers shall be collectively responsible to the Lok Sabha. It means that the ministry stays in office so long as it enjoys the confidence of the majority of the members of the Lok Sabha. In other words, the Lok Sabha can remove the ministry from office by passing a no-confidence motion. The motion needs the support of 50 members to be admitted. A no-confidence motion in the Council of Ministers is distinct from a censure motion. Whereas a censure motion must set out the grounds or charge on which it is based and is moved for the specific purpose of censuring the government for certain policies and actions, a motion of no confidence need not set out any grounds on which it is based. The giving of reasons is not a condition precedent to the admission of a motion of no confidence. So, Statement 1 is not correct. When leave of the House to the moving of a motion has been granted, no substantive motion on policy matters is to be brought before the House by the government till the motion of no confidence has been disposed of. There is no restriction on moving more than one no-confidence motion in a session, although this has not been done so far, which may be necessitated on account of some new developments that might have taken place since the discussion on the first motion. The second motion would, therefore, be admissible only if it is based on new matters not covered by the discussion on the previous motion. So,
Statement 2 is not correct.
AI.
26 out of 27 no-confidence motions have been voted upon and rejected. This means that no government has ever had to resign following a vote of no confidence. On one occasion, in 1979, the discussion on a no-confidence motion against the Morarji Desai government remained inconclusive. He resigned before the motion was put to vote. 50% of all no-confidence motions, 14 out of 28, were discussed between 1965 and 1975. Of these, 12 were against governments headed by Indira Gandhi. So, Statement 3 is
correct.
Therefore, option B is the correct answer. Relevance. The non-confidence motion was recently defeated in the Lok Sabha monsoon session of 2023.
AI.
Consider the following statements. Statement I. territorial constituencies of the states can be readjusted only without altering the number of seats allotted to each
state in the Lok Sabha.
Statement 2. The Representation of the People Act of 1951 has frozen the allocation of seats to the states in the Lok Sabha. Which one of the following is correct in respect of the above statements? A. Both Statement I and Statement 2 are correct and Statement 2 is the correct
Explanation for Statement I.
B. Both Statement I and Statement 2 are correct and Statement 2 is not the correct explanation for Statement I. C. Statement I is correct but Statement 2 is
Incorrect.
D. Statement I is incorrect but Statement 2
Is correct. Answer C. Explanation.
Following each census, it is essential to review and modify A. The distribution of seats among states in the Lok Sabha and B. The demarcation of territorial constituencies within each state. The responsibility to establish the process and jurisdiction for this adjustment lies with the Parliament. Accordingly, the Parliament enacted the Delimitation Commission Acts in 1952, 1962, 1972 and 2002 for this purpose. The 42nd Constitutional Amendment Act of 1976 froze the allocation of seats in the Lok Sabha to the states and the division of each state into territorial constituencies till the year 2000 at the 1971 level. This ban on readjustment was extended for another 25 years, i.e., up to the year 2026. By the 84th Constitutional Amendment Act of 2001, with the same objective of encouraging population limiting measures. So, Statement 2 is not correct. The 84th Constitutional Amendment Act of 2001 empowered the government to undertake readjustment and rationalization of territorial constituencies in the states on the basis of the population figures of the 1991 census. Later, the 87th Amendment Act of 2003 provided for the delimitation of constituencies on the basis of the 2001 census and not the 1991 census. However, this can be done without altering the number of seats allotted to each state in the Lok Sabha. So, Statement
1 is correct.
So, Statement I is correct but Statement 2 is incorrect. Therefore, Option C is the correct answer. Relevance. The Prime Minister of India recently said that the number of seats in members of Parliament will
increase in the coming time.
AI.
Which one of the following parliamentary committees is responsible for scrutinizing details of expenditure charged upon the
Consolidated Fund of India. A. Public Accounts Committee.
B. Committee on Public Undertakings. C. Joint Committee on Salaries and
Allowances of Members. D. Committee on Estimates.
AI.
Answer D. Explanation.
The origin of the Estimates Committee can be traced to the Standing Financial Committee set up in 1921. The first Estimates Committee in the post-independence era was constituted in 1950 on the recommendation of John Mackay, the then Union Finance Minister. Originally, it had 25 members but in 1956 its membership was raised to 30. All the 30 members are from Lok Sabha only. The Rajya Sabha has no representation in this committee. The Committee on Estimates can call for the details of expenditure charged upon the Consolidated Fund of India and scrutinize whether the classification of items of expenditure between voted and charged has been done strictly in accordance with the provisions of the Constitution and Acts of Parliament. Estimates related to expenditure other than that charged upon the Consolidated Fund of India is submitted to the Lok Sabha in the form of demands for grants. The Lok Sabha has the power to assent or to refuse to assent to any demand or to assent to any demand subject to the reduction of the amount
specified therein.
Therefore, Option D is the correct answer. (16) Consider the following statements with reference to a constitutional amendment bill. 1. It can be initiated in either house of the
Parliament.
2. Prior permission of the President is required for its introduction in the House. 3. All such bills must be ratified by the legislatures of half of the states by a
Special majority.
Which of the statements given above are not
Correct? A. 1 and 2 only. B. 2 and 3 only. C. 1 and 3 only. D. 1, 2 and 3. Answer B. Explanation.
Article 368 in Part 20 of the Constitution deals with the powers of Parliament to amend the Constitution and its procedure. The procedure for the amendment of the Constitution as laid down in Article 368 is as follows. An amendment of the Constitution can be initiated only by the introduction of a bill for the purpose in either House of Parliament and not in the state legislatures. So, Statement 1 is correct. The bill can be introduced either by a minister or by a private member and does not require prior permission of the President. So, Statement 2 is not correct. The bill must be passed in each house by a special majority, that is, a majority of the total membership of the House and a majority of 2/3 of the members of the House present and voting. Each house must pass the bill separately. In case of a disagreement between the two houses, there is no provision for holding a joint sitting of the houses. Not all constitutional amendments but only the bill that seeks to amend the federal provisions of the Constitution must also be ratified by the legislatures of half of the states by a simple majority, that is, a majority of the members of the House present and voting. So, Statement 3 is not correct. Therefore, Option B is the answer.
AI.
Which of the following features is R. common to the Rajya Sabha of India and the Senate of the United States of America?
USA.
1. Indirect election of members. 2. Equal representation to all states.
3. 6-year term for members.
4. Appointment of nominated members. Select the correct answer using the code
Given below. A. 1 and 2 only. B. 3 only. C. 1, 2 and 3 only. D. 3 and 4 only. Answer B. Explanation.
The representatives of states in the Rajya Sabha are elected by the elected members of state legislative assemblies. The election is held in accordance with the system of proportional representation by means of the single transferable vote. The seats are allotted to the states in the Rajya Sabha on the basis of population. Hence, the number of representatives varies from state to state. For example, Uttar Pradesh has 31 members while Tripura has 1 member only. In the United States of America, USA, all states are given equal representation in the Senate. Irrespective of their population, the Senate is composed of 100 senators, 2 for each state. Until the ratification of the 17th Amendment in 1913, senators were chosen by state legislatures, not by popular vote. Since then, they have been elected to 6-year terms by the people of each state through direct elections. So, points 1 and 2 are not correct. The Constitution has not fixed the term of office of members of the Rajya Sabha and left it to the Parliament. Accordingly, the Parliament in the Representation of the People Act, 1951, provided that the term of office of a member of the Rajya Sabha shall be 6 years. On the other hand, the members of the American Senate have been elected to 6-year terms by the people of each state. So, point 3 is
correct.
12 individuals possessing exceptional expertise or practical experience in fields such as art, literature, science and social service are appointed by the President of India to the Rajya Sabha. The rationale behind this principle of nomination is to provide eminent persons a place in the Rajya Sabha. Without going through the process of election, it should be noted here that the American Senate has no nominated members. So, point 4 is not correct. Therefore, option B is the correct answer.
AI.
Consider the following statements with Reference to the Parliament of India. 1. The recommendation of the President is required for amending provisions for the reduction of any tax in Parliament. 2. An Act of Parliament cannot be deemed void only due to the absence of the necessary recommendation from the
President.
Which of the statements given above is are
Correct? A. 1 only. B. 2 only. C. Both 1 and 2. D. Neither 1 nor 2. Answer B. Explanation.
Certain bills cannot be introduced in Parliament or proceeded without the recommendation of the President has been received. According to the rules of procedure and conduct of business in Lok Sabha, the recommendation of the President is required for the following types of bills. O. The recommendation of the President is required for the introduction of bills and for moving amendments relating to financial matters. However, no recommendation is required for moving an amendment making provision for the reduction or abolition of any tax. So, Statement 1 is not
Correct.
O. For the introduction of a bill or moving of an amendment affecting taxation in which states are
Interested.
O. For consideration of a bill which, if enacted, would involve expenditure from the Consolidated Fund
Of India.
No Act of Parliament, or provision in any such act, would be held void just because the President did not provide the necessary recommendation or prior sanction. Such requirements are solely considered procedural. So, Statement 2 is correct. Therefore, Option B is the correct answer.
AI.
Consider the following. 1. Members of the Niti Aayog.
2. Chairperson of the National Commission
For minorities.
3. Controller and Auditor General of India.
CAG.
4. Members of the Central Vigilance
Commission, CVC. 5. Governors of states. 6. Judges of the High Courts.
With reference to the Constitution of India, how many of the above are appointed by the President by warrant under his hand and
seal? A. Only 3. B. Only 4. C. Only 5. D. All 6. Answer B. Explanation.
In India, the phrase, by warrant under his hand and seal, signifies that the President is the final authority in these cases and that there would be a signature of the President on the appointment letter. In other cases where the President is the appointing authority, it is not necessary that he is the final appointing authority. He might delegate his function to some other authority. For example, the appointment of officers is done by the President, but in general it carries the signature of the Secretary of the concerned department. The following are among the functionaries that are appointed by the President by warrant under his
hand and seal.
O. Chairperson and members of the National Commission for Scheduled Castes, SCs, Article 338. O. Chairperson and members of the National Commission for Scheduled Tribes, STs, Article 338A. O. Chairperson and members of the National Commission for Backward Classes, BCs, Article 338B. O. Chairperson and members of the National Human Rights Commission, NHRC. O. Controller and Auditor General of India, CAG, Article 148. So, point 3 is correct. O. Chairperson and members of the Central Vigilance Commission, CVC. So, point 4 is correct. O. Governors of States, Article 155. So, point 5 is correct. O. Judges of the Supreme Court and High Courts, Articles 124 and 217. So, point 6 is correct. Niti Aayog consists of ex officio and other members appointed by the Prime Minister. So, point 1 is
not correct.
The chairperson and members of the National Commission for Minorities are nominated by the central government from amongst persons of eminence, ability and integrity. So, point 2 is not correct. So, only 4 of the above are appointed by the President by warrant under his hand and seal. Therefore, option B is the correct answer.
AI.
In which one of the following judicial cases, the Supreme Court of India ordered an immediate disqualification of a member of Parliament, MP, who was convicted of a crime and sentenced to at least 2 years in
jail?
A. Vishaka vs. State of Rajasthan, 1997. B. Shreya Singhal vs. Union of India, 2015. C. Lily Thomas vs. Union of India, 2013. D. P.V. Narasimha Rao vs. Union of India, 1998.
Answer C. Explanation.
In the legal case of Lily Thomas vs. Union of India, 2013, a significant ruling was made by the Supreme Court. The case revolved around Section 8(4) of the Representation of the People Act, RPA, 1951, which shielded convicted politicians from disqualification to contest elections while their appeals were
pending.
Section 8(4) of the RPA allowed convicted members of Parliament, MPs, members of the Legislative Assembly, MLAs, and members of Legislative Council, MLCs, to continue in their posts, provided they appealed against their conviction, sentence in higher courts within 3 months of the date of judgment by the trial court. The crux of the Supreme Court's decision in the Lily Thomas case was that any elected MP, MLA or MLC who is convicted of a crime and sentenced to at least 2 years of imprisonment would promptly lose their membership in the respective house. This ruling was applicable even if the elected official appealed the conviction. Importantly, the safeguard provided under Section 8(4) would not apply if the conviction was handed down by a trial court. In essence, the Lily Thomas vs. Union of India case solidified the principle that elected representatives facing serious criminal convictions would be swiftly disqualified from their positions, promoting accountability and upholding the integrity of public office. Therefore, option C is the correct answer. Relevance. Recently, a member of Parliament was disqualified based on the Supreme Court ruling in its landmark 2013 Lily Thomas v. Union of India case, which earlier also led to the disqualification of legislators like Jayalalitha
And Azam Khan.